The court is very concerned, Mr. Connor, that less than a year has elapsed since your sentencing on the prior one, and you're back here in front of us, allegations of the same exact stuff, and possibly even a little worse.
Is, when I look at the docket,
Walter Connor?
Number 9, yes.
Okay, we're on for arraignment. And have you had a chance to review the police reports?
Yes, Your Honor. Mr. Connor and I have discussed his rights. I've advised him of his rights. I believe he understands them. There's no contest for purposes of today's hearing to probable cause. I would just ask the court to enter a not guilty plea and appoint Thurston County Public Defense going forward.
Okay, based on stipulations of counsel, I will find probable cause. I'll enter a plea of not guilty. I believe just a moment, please. Believe I heard that counsel appointment would be appropriate, so I will appoint counsel. And I will hear from the state on conditions of release.
Firstly, Your Honor, the state at this time, and I can follow up in writing if that would be better, but the state at this time would like to add the charge of driving while license suspended third to this case. In the police report, it indicates that the defendant was found to be driving while license suspended.
Hold on a moment. You're not sworn, so let me see if there's any need to swear you in. Do you stipulate to driving while license suspended in the third for the limited purpose of today's hearing?
Are you asking us, Your Honor?
Yes, I am.
I think there would be no contest for the purposes of today's hearing to that, and we would enter a plea of not guilty on that as well, Your Honor. Okay.
I'll note the oral amendment, and I would like a written one just for the file. But based on stipulations of counsel, I will find probable cause for driving while license suspended in the third, enter a plea of not guilty on that as well. And now I will hear conditions of release.
For release conditions, Your Honor, the state will be asking for $10,000 bail, the imposition of a scram device, as well as the imposition of an ignition interlock device. The ignition interlock device is required by law because the defendant was convicted of a DUI in this very court, actually in front of Your Honor and with me as the DPA of DUI back in, I believe, October of last year. I'll pull it up on JABS just to make sure that I have that date correct. Yes, October 23rd of 2023, the DUI was amended to a negligent driving in the first degree. And the driving while license suspended third charge was dismissed pursuant to the plea agreement. So, Your Honor, the defendant has failed to abide by probation. So I'll get to the probation matter as well in a minute. But the rationale for what I'm going to ask on probation overlaps for the rationale for the $10,000 bail on the scram device. Probation, and he failed to follow those terms of probation by driving with a suspended license, which constitutes a violation, by consuming alcohol, which is a violation. It came in on the breath ticket in this case. The BAC in this case was a 0.128 on the low end. So we have consumption of alcohol, which is also a violation, and we also have probable cause stipulated to for violations as well. So on that basis, I'm asking for $10,000 bail on the new charge, and on the old charge, I'm asking the court to revoke probation, and that would be on cause number ending in 798. I'm asking the court to revoke the release on probation and to hold the defendant without bail on that cause pending a sanctioned hearing.
Thank you. I will hear from defense, please.
Your Honor, we would ask for bail of no more than $500 on the new on the new matter, the new alleged violation, and would ask for bail again of no more than $500 on the prior matter. And the imposition of any bail based on my conversation with Mr. Connor on the matter on for arraignment would be equivalent to holding him with no bail, as he's not able to pay any amount of bail realistically. I understand that the state is entitled to ask for a no bail hold on when revoking probation, but he does still enjoy the presumption of innocence as well as the presumption of release on the new charge. So if the court is inclined to hold him without bail on the probation, I would ask that no bail be set on the new matter. However, enhanced DUI conditions, no objection to that.
Okay, since there's no objection to the enhanced DUI conditions, those will be conditions. As far as bail or holding without bail on the backup matter, the court is very concerned, Mr. Connor, that less than a year has elapsed since your sentencing on the prior one, and you're back here in front of us, allegations of the same exact stuff, and possibly even a little worse. I do think bail is appropriate. Given what I have seen and heard, I have concerns for our community. I have concerns. Now, let me take a look at something. I am not seeing any prior failures to appear on this matter. Well, on the backup matter.
No, Your Honor.
The defendant doesn't have any warrant history in Washington that I'm seeing.
Okay. So what I'm going to do is I'm going to impose, I'm going to note the oral motion to revoke. If you are able to make bail, Mr. Connor, understand you're going to have a hearing coming up on a failure to comply probably pretty quickly on this matter. I'm going to set the bail on the new cause number, cause ending 7403 at 2500, 7403, I apologize. And I will be imposing, as I said, the enhanced conditions. Mr. Connor, I'm doing that because I don't specifically remember you from however many months ago. But as I said, I am concerned that you are just here. And I know darn near everyone who's in front of me for sentencing says something to the effect of, it won't happen again. You're not going to see me back in here for anything. These are just allegations. I don't know what really happened, but I do have concerns. So you will need to get a SCRAM device, a transdermal alcohol monitoring device, within 48 hours of release. What do we have for a next hearing for in custody?
Your Honor, just very briefly. Is the court imposing any bail on the probation matter?
Yes. I think $1,000 on that would be appropriate as well.
And I understand if the court wants to address this issue at a separate hearing, but my understanding for finding a violation of probation is all the court needs is clear and convincing evidence. of that violation.
And at the moment, I am not going to find there's been a violation.
Okay.
The probable cause was stipulated for purposes of release conditions. And while I understand many judges would accept that, I am not going to.
I agree, Your Honor. That's not acceptable for finding a violation, but I can send over the police report, which has the BAC ticket on it. And I believe that rises above.
You could. We're not going to do that today.
Okay, understood.
Thank you, Your Honor. Is that all for Mr. Connor?
That is, I'll have the paperwork done in just a moment here.